Good afternoon. Please be seated. Welcome to Division 5 of the Court of Appeals. My name is Gilbert Roman, and I'll be presiding today. To my right is Judge David Richmond. To my left is Judge Mike Berger. We have 3 cases on the docket today, one in the 130, or 2 on the 130, and then 1 in the 230. The 130 docket is People v. Martinez, 2016 CA 945. Looks like counsel are here, present, and ready to go. Do you have any questions before we get started about the process? All right. And then the second case is Rocky Mountain Gun Owners versus Hickenlooper, and our counsel for that case here. And while you're both up, do you have any questions about the process before we get started? No, Your Honor. No. Okay, very good, thank you. And although they aren't required to be here, I'll just check in anyway. To the 230 docket, Lang versus DeFada, our counsel here for that case.
Yes, Gavin, only for the Pueblo County licensing.
Okay, thank you, welcome. And the other 2 are not here yet, it looks like. We'll be taking a short break after the second case and before the 230 docket. For this case, I would ask everybody in the gallery, if you have a phone or a device that makes noise that would go off, please turn it off now. Not down, but off. And I would remind the attorneys today that this is being streamed live, and also that it will go into the court's archives, so anybody can go back and check it later. To the appellant, you have 15 minutes. You both do, but you have rebuttal time. It'll be up to you to save your rebuttal time. And I'll try to help you with that, but it's a hot bench sometimes, and so keep in mind that in the end it's up to you, all right? And with that, I believe we are ready to go with the first case, People v. Martinez.
Thanks, judges. My name is Joe Goodner, registration number 41941, and I represent Pete Martinez, the defendant appellant. In response to the court's question, several jurisdictions do allow juvenile crimes to trigger habitual punishment, which is a point that we do not contest. But very few jurisdictions have answered the question that Mr. Martinez raises, which is whether courts must individually sentence these juvenile predicates. The Iowa Supreme Court in State v. Bruger, 773 Northwest 2D 862, 2009, is one of the few jurisdictions that has addressed this specific question. And its decision is particularly interesting because it came out before Graham and Miller ever talked about individually sentencing juvenile crimes, and I believe it reached the correct conclusion. 21-year-old Jordan Bruger faced a sentence under 10 years, but received a mandatory 25-year sentence instead because of a prior crime that he committed when he was 12 years old. The Iowa Supreme Court reversed and remanded for, quote, an individualized assessment of the punishment imposed, stating that the focus is on the current crime and that Bruger did commit his current crime as an adult.
But isn't that just a proportionality analysis as opposed to what you're requesting us to order? I mean, you're saying that the trial judge ought to somehow evaluate where in life the defendant was when he was convicted as a juvenile?
I'm suggesting...
Aren't these 2 different things?
I don't think so. The trial court in Bruger, prior to going up on appeal, and the trial court here both refused to consider the fact at all that the defendant's prior crimes that were being used to enhance his adult punishment occurred when he was a juvenile. And I believe that's inconsistent with Graham and Miller, that youth matters for sentencing purposes. To ignore completely that the defendant was a juvenile, he's being punished for, it's not an additional element of, say, motor vehicle theft that he was charged with. He's being punished with a separate act of reoffending. And his culpability as a reoffender is related to his culpability for initially offending in the first place. And when 2 of the 3 initial offenses occurred when he was a child, and as a matter of Eighth Amendment constitutional law, youth matters for sentencing purposes, I believe that it was incorrect for the court to refuse to consider that in any way. And so I believe that he should get an individualized assessment, an individualized sentencing hearing where he can demonstrate that he was operating with reduced culpability due to the distinctive attributes of youth, and demonstrate how that lessened his culpability for reoffending under the habitual statute. And I believe that's consistent with the purpose of the habitual statute, which is to proportion punishment to an individual's prior criminal history. And the Roper, Graham, and Miller make clear that a juvenile criminal history is different. It's constitutionally different. It's fundamentally different as a matter of fact and law than an adult criminal history, and I believe the court was wrong to refuse to consider that.
In Miller and those cases, when they say youth mattered, they were talking about in the context of committing a murder, correct? Is there any case where they said youth mattered in a non-murder case?
That case has not reached the Supreme Court. What I would point out, though, is that...
So the answer is not yet, you're saying?
The answer is no, but I do believe those cases stand for a larger principle. It started in 1988 with a holding that you can't execute 15-year-olds. It expanded in 2005 to a holding that you can't execute 17-year-olds. And each of these subsequent decisions was because states continued to limit each of these cases to their facts. And then in 2010, it expanded to life without parole, and again in 2012. And I think that the U.S. Supreme Court has refused to limit these cases to the facts of any prior case because each of the cases stands for a larger principle. And the larger principle is that youth matters when it comes to applying adult sentencing statutes to juvenile conduct.
So are you saying that the habitual criminal statute is unconstitutional as applied to your client?
That's correct. Or at the very least, I believe that he needs an opportunity to demonstrate that it is. He wasn't given an opportunity to develop the record on whether it is unconstitutional as applied to him, because although he pointed out to the court that 2 of his 3 prior offenses occurred when he was a juvenile, the court found no authority to take that into consideration in any way. And so I don't know that we have the appropriate record to determine whether it's unconstitutional as applied to him, but that he should have an opportunity in a remanded sentencing hearing for an individualized determination to show that it is.
Now, the individualized determination they talk about in Miller or Montgomery is an individualized determination as to the offense that's being directly appealed. And you want this court to go one step further, or the trial to go one step further, and do an individualized determination of a crime that occurred with no record before that court, but before some other court. That's what you're asking us to direct?
Correct. It's for the predicate that was used to enhance his adult punishment. And I think that's necessary to ensure that the consequences of his juvenile act don't become disproportionate to his punishment for his adult crime.
So how would the court do that? How would the trial court do what you're saying ought to be done? What procedures would be used? What kind of evidence do you contemplate? How would the court do that?
I think with any trial proceeding, both parties could bring forward, evidence. Could be certified court records. It could be.
Well, we already have that. We know he was convicted. You're saying you got to get into the defendant's state of mind, presumably years earlier, to see if he ought to be held to the adult consequences of that crime?
Yeah, and I don't think the record's completely developed just by showing that the prior conviction exists. And Miller and Graham talk about different factors. For example, was the crime committed with older people? Was it possibly the result of peer pressure? What was going on with respect to a defendant's family life that might demonstrate Because the habitual statute exists to ferret out people who are incorrigible, people who cannot be rehabilitated. And the act of a juvenile does not combine together, with a future crime the same way that an act of an adult does to show that someone is irredeemable. And I think these traits that are discussed in Graham and Miller, was the crime possibly committed with older children? Was it the result of peer pressure? What was going on, in the home life and other things like that? And I think there's a presumption of diminished culpability, just, on 30 years of U.S. Supreme Court precedent on, relying on social science for the distinction between.
But counsel, why doesn't it make a difference if a juvenile is tried and convicted under the juvenile system as a juvenile versus tried and convicted as an adult?
Well, I think there is a distinction there that's not present in this case. If somebody is adjudicated a delinquent and then that is then used as a predicate without a jury trial, I think there's an Apprendi issue. That's not present in this case. But the fact that he was tried in the adult system doesn't change the fact that he was a juvenile and that he had diminished juvenile culpability when 2 of the 3 prior offenses used to, show that he's this irredeemable habitual criminal occurred. And I think that he deserves an opportunity to show that the prior crimes were not a result of incorrigibility. They don't demonstrate habitual criminality, and that they demonstrate, he was basically a kid that wasn't thinking about the future.
But again, in the Miller type case, the record's before the court. They can make those kinds of determinations. Was it a felony murder situation? Is obviously one of the ones they start with. He just went along with somebody else. In this case, you're saying they should go back, look at a case that might be 10 years old, get the record, and try to figure out what the circumstances that the defendant was facing at that time? That's what you're suggesting?
If that's the evidence that's available to trial counsel, correct. I think that they should have been given an opportunity to make a record on that, and that could have been, part of the record that was made on that type of
Who
question.
has the burden to show that he is or is not incorrigible, under your theory?
It would be his motion. I believe it would be his burden. But I believe at a minimum he should have an opportunity regardless of where the burden lies. May I reserve the remaining time for rebuttal?
You may.
Thank you.
You have 4 minutes and 50 seconds left.
May it please the court. Elizabeth Ford Milani, registration number 48843 for the people. With the exception of correcting the minimus, this court should affirm. The trial court properly adjudicated defendant an habitual offender. The trial court's theory of the case instruction was proper, and the burden did not shift to the defendant. I want to start by addressing the court's question with regard to issue 3, whether juvenile convictions may serve as predicates for recidivist or habitual sentencing. I found several cases across the country in various states post Graham and Miller that allow convictions entered when the defendant was a juvenile to serve as a predicate for recidivist or habitual sentencing. Now, some cases in various jurisdictions drew a line with juvenile adjudications and did not allow juvenile adjudications to serve as predicates, but other courts talk about if it's a juvenile conviction, it may serve.
In Colorado, can a juvenile adjudication be used under the Habitual Criminal Act?
I don't think that that would be supported because I think adjudications are not felonies. And under the Habitual Criminal Act, the reference is to a felony, which is
Well,
what...
they're not convictions, are they?
Right,
I mean,
they're not...
an adjudication is not a conviction.
Exactly. So I think that it wouldn't fall in that regard. But, the record that we have in this case was that defendant was convicted. He pled guilty to crimes in district court. In both of the juvenile offenses that we'll say, he was sentenced to the DOC. Nothing to suggest that these were adjudications from the record. Not only have cases throughout the country said that a juvenile conviction can serve as a predicate for habitual recidivist sentencing. Some cases have gone so far as to say even where a defendant gets a life without parole sentence based on convictions entered as a juvenile, that does not offend Graham and Miller. Because the important point, and I think that what resolves this case, is the fact that defendant was sentenced for his current crime. As the Supreme Court said in United States v. Rodriguez, 100% of the penalty on a recidivist or habitual sentencing scheme is for the crime of conviction, the most recent crime. Defendant was not a juvenile when he committed aggravated motor vehicle theft and eluding. He was an adult. Therefore, this fact on its own takes this case outside the parameters of Graham and Miller. Not only that, but defendant received 12 years, not a life sentence as discussed in Graham.
Did any of those cases address the theory that the defendant is now asserting?
I didn't find anything. I found one case from Kentucky, and by statute, that state requires recidivist or habitual sentencing to be based on convictions that were entered when the defendant was 18 or older, but that's by statute. Other cases that have similar statutes that we do, where it just frames the predicates in terms of felony, allow juvenile convictions to support a habitualist or recidivist regime. I think that in all other respects, the trial court's proportionality review was proper. And I want to comment on one thing. Opposing counsel raised that the juvenile, or that the defendant didn't have the opportunity to sort of challenge this approach. At the habitual sentencing, opposing counsel, defense counsel, did talk about how defendant was a juvenile. That was definitely brought up. But at no time did counsel say, the defendant cannot be adjudicated a habitual offender until these facts, until this fact-finding occurs, until we're able to make a record on this. So I think that to the extent the defendant is arguing that the trial court should have done something else, should have had some sort of different hearing to probe back into his state of mind at the time he was a juvenile, that's unpreserved. And I was not able to find any authority in Colorado or elsewhere that this sort of hearing exists outside of the Graham-Miller context where the defendant is a juvenile and they are committing crimes as a juvenile, which is not the case here, of course.
Did counsel suggest that the statute is unconstitutional as applied to the defendant?
The people disagree. I think that it's...
No, in the trial level. Did
Oh,
the
at the
trial counsel make the argument that the appellate counsel just made?
Not that I
Statement.
recall. And not on its face or as applied. That wasn't raised. And I think that to the extent that there's any sort of Apprendi issue or Blakely issue in regard to the habitual criminal statute, that argument has been squarely rejected by this court. The prior conviction exception of Apprendi still lives, and it applies here. I'm happy to provide those citations to the state courts if I can read off some highlights. Wilson v. State, that's 521 Southwest 3D 123. Molnar v. State, 406 P. 3rd 473. State v. Leon, 292 P. 3rd 493. State v. Green, 770 Southeast 2D 424. And then I'll provide that Kentucky state that talked about the statute requiring 18 years old. That's 288 Southwest 3D 291.
And Mr. Goodner, I'll give you 7 days to respond to those if you'd like, all right?
Unless the court has any further questions about the habitual criminal statute, turning to the theory of the case instruction in this, the trial court did not abuse its discretion by taking the defendant's tendered instruction and crafting one that complied with the rules and that was supported by the evidence. The evidence set out the following. Defendant told the victim a motorcycle was not stolen. Defendant told the victim the motorcycle ran clean when he was pulled over. The victim did not believe the defendant was the one who stole the motorcycle, and there was no evidence of hot wiring on the motorcycle. None of these facts really directly pertain to where the defendant got the motorcycle. So even if the trial court erred by not giving the instruction that defendant lawfully came into possession of the motorcycle, I think under this court's recent decision in Houston, that error would be harmless because under that analysis, no reasonable juror would have credited the defense point that defendant obtained the motorcycle somehow lawfully. There just was no evidence on how he got it, how it came to be in his possession. So I think this court, with regard to that point, need not even reach that question. And I think the trial court's instruction in this case adequately covered the other points, and defense counsel was able to make argument in closing. With respect to the burden shifting argument, I think that under Santana, the analysis shakes out that there was no burden shifting at all. The prosecutor never argued that the defendant, in order to be found not guilty, had to prove something or bring forth evidence. A prosecutor may comment on the lack of evidence supporting a defendant's theory, and that's exactly what happened here. And in any event, the prosecutor, defense counsel, the trial court, and the written instructions all reiterated where the burden of proof was set.
But isn't there a difference between a prosecutor saying, you've heard no evidence supporting the theory of the case instruction, and maybe it's a subtle difference, but a difference then for the prosecutor to instead say, but the reason you didn't hear any evidence supporting the theory of the case instruction is that the defendant didn't present any evidence, didn't either testify, we don't have that here,
Sure.
or didn't cross-examine a witness. I mean, it seems to me you're getting close to the point where the prosecutor really is telling the jury, they didn't present any evidence and therefore he's guilty.
With regard to the fine line, I agree that it's pretty subtle, and I think that in that regard, what the prosecutor did here falls under the line of the subpoena power cases, where the prosecutor, in other cases before this court, the prosecutor has acknowledged that the defense can provide evidence, i.e. the defense has subpoena power, but it wasn't used. And so I think that even on that side of the line, which is arguably where the prosecutor went, I think it's still perfectly permissible under this court's authority. And what I think is just also very relevant here is how many times it was stressed to the jury. The burden does not shift. So in this case, there was no intent to shift the burden, and there was no question that the jury was improperly instructed in any way.
It's not okay for the prosecutor to say defendant didn't bring forth evidence, but it's okay for the prosecutor to say he could have brought forth evidence, but he didn't. That's a distinction that you're making?
I don't think so, and to the extent I did, I don't want to make that distinction. I think the Herrera case talks about it is improper for a prosecutor to say, because the defendant didn't bring forth evidence, therefore he didn't prove he's not guilty.
Okay.
Thus, you have to find him not guilty. Right. But I think that other cases since Herrera and pre-Herrera have talked about a prosecutor may say, this was defendant's theory. You didn't hear that. You didn't hear any evidence of that. And defendant has the same subpoena power as the people to bring forth that evidence. So I think in this case, the prosecutor's actions were perfectly permissible. The trial court's admonishment to the jury corrected or neutralized any remaining effect of the burden shifting. Unless this court has further questions, with the exception of the correction of the minimus, the people encourage the court to affirm.
Thank you, counsel. Mr. Goodner, you have 4 minutes and 50 seconds remaining.
Thank you. I'd just like to respond to the point about the subpoena cases. The subpoena cases start with a Colorado Supreme Court case called Medina. And in Medina, the defendant said that 2 specifically named witnesses would have provided an alibi for him. And the prosecution pointed out that if this were true, why didn't he call those witnesses? And another case that I think is instructive along those lines is Reeves. The defendant said, look, I had a prescription for those drugs. And the prosecutor pointed out that no evidence in the record whatsoever proved that the defendant had a prescription for those drugs. So
in both cases, the conviction was affirmed. Or was it, you told us what the cases are, but you didn't tell us the result. Was the prosecutor's statement considered to be misconduct?
Not in those cases.
Both cases, okay.
Correct.
Now,
and
you're going to tell us why this one's different.
That's right. Okay. And so in those cases, the defendant asserted that evidence that had not been produced supported his theory of defense. These two witnesses support my theory of defense. Those witnesses are not here. This prescription for these drugs supports my theory of defense. Those aren't here. Now, Mr. Martinez argued that he thought he lawfully possessed the motorcycle, and enough evidence supported that for the jury to agree with him. The motorcycle was not hot-wired, and there was evidence, if the jury believed it or not, would have been a jury call, but the jury could have believed that he had been pulled over by a highway patrolman and that the motorcycle ran clean. And Mr. Martinez...
I'm lost now. Which point are you addressing now? Are you addressing the theory of the case instruction?
The burden shifting.
You are, okay.
Thank you for clarifying. What I mean to say is that this isn't a situation like in Medina or Esquivel-Alanis where the prosecutor permissibly commented on the lack of evidence, because Mr. Martinez did not base his theory on no evidence. He based his theory on evidence that was actually before the jury. And when a defendant bases his theory on evidence that's actually before the jury, he does not open the door for the prosecution to catalog every other single piece of conceivable evidence that he might have also presented to further support his theory, because that implies that he has a burden to present a higher quantum of proof.
No, but don't the courts say that when a defendant doesn't have to state a theory of defense, he can just say they didn't prove it. But when the defendant does request and receive a theory of the case instruction, don't the cases say that the prosecutor is entitled to say, there's no evidence to support that theory of the case instruction?
I agree with that, but I don't believe that's the case here. Mr. Martinez's theory was that he thought he owned the motorcycle. The motorcycle was not hot-wired, and there was evidence that the jury could have believed that showed that he had been pulled over by a highway patrolman and that the motorcycle had ran clean. The jury may have chosen to believe or disbelieve that evidence, but that evidence did support his theory. A person who operates a motorcycle with a key and a person who has been pulled over by law enforcement and passes a traffic stop can reasonably believe that they owned the motorcycle, even if they happen to be mistaken about it. So this isn't a situation where no evidence supported his theory. Evidence did support his theory. The prosecution took it a step further and essentially said, well, that evidence wasn't good enough. He should have presented more evidence. He didn't meet his burden of proof.
Didn't he suggest to the jury that he had lawfully come into possession of this motorcycle?
He said he thought he did.
Okay.
He said he thought he lawfully possessed the motorcycle.
And the prosecutor said, where's the title transfer?
Right. Where's the bill of sale? Correct.
So doesn't that respond to his offer of evidence that he lawfully came into possession of the motorcycle, like the prescriptions in the other case you cited?
I don't believe so, because in the prescription case, the defendant said, I have a prescription. Mr. Martinez never said, I have a bill of sale. He never said a bill of sale proves that he lawfully owned it. He never said that the seller, as a witness who he never called, would have proven that he lawfully owned it. He said that these other pieces of evidence that were actually before the jury proved his theory, and he had no higher burden of proof. That evidence was good enough. And I do dispute that the court correctly instructed the jury. The court told the jury that the law never imposes in a criminal case the burden of presenting any evidence or I don't have it right here. Okay, here we go. The law never imposes in a criminal case the burden of calling any witnesses or producing any evidence. That is simply not true. The law imposes such a burden on the prosecution and not on the defendant. And considering that jurors are lay people, the court needed to make that absolutely clear. And after...
And counsel, your time's up.
Thank you kindly.
Thank you both for your fine arguments. The case will stand submitted and an opinion will issue in due course. We will set up now for the second case on the 1:30 docket, Rocky Mountain Gun Owners versus Hickenlooper. And counsel, again, as the appellant, You each have 15 minutes, but you can also save some time for rebuttal.
I do expect to save some time. Thank you, Your Honor.
You may proceed.
May it please the court, my name is Barry Arrington, 16486. I represent the appellants. In the Supreme Court cases with respect to the right to keep and bear arms under Article 2, Section 13 of the Colorado Constitution, the court has said that the standard is a reasonableness standard. And the cases that have come down, including Robertson and City of Lakewood versus Pillow, that part of that reasonableness standard is whether the law sweeps unnecessarily broadly. That was an issue in both Robertson and City of Lakewood. In this case, we are up here for the second time. The first time we were here was on a motion to dismiss that this court said was improperly granted because the plaintiffs pled that the effect of House Bill 1224 was to ban virtually every magazine that is out there because these magazines with detachable base plates can be readily converted to accept more than 15 rounds of ammunition. The trial court dismissed the case, and this court said that was wrong. If they can prove that, if they can prove what they've pled, that states a claim under Article 2, Section 13.
Counsel, can I stop you right there? I just want to make sure that we're all on the same page. So the first court, Rocky Mountain Gun Owners 1, came down and applied the Robertson reasonableness standard and applied it to the Colorado Constitution. Are you agreeing that that is the correct standard that we should be, that brings us here today, and that's how we should analyze this case?
Of course, yes.
Okay, very good. Thank you. Proceed.
And so, and what we're saying is this idea of sweeping unnecessarily broadly. In Robertson itself, where it said, this is only 40 out of 2,000 weapons. It's not very broad. And in City of Lakewood, which was not overruled, is specifically said the gun regulation can't sweep unnecessarily broadly. And we're saying that that's what happened. We pled that. The court said that if you, in fact, prove, you're entitled to go to trial and try to prove what you plead. And if you do, that states a claim.
So, Mr. Arrington, you are not contending that a broader, more strict standard of review applies to this Colorado constitutional claim. Is that right?
We do contend that, but we do also recognize that this court has already held that that's not the case. The court.
Well, this division hasn't done anything yet.
Okay.
And
Well,
this
okay.
division is not bound by another division of the Court of Appeals.
Okay, and if this division wants to say that the Article 2, Section 3 sweeps more broadly than the Second Amendment, I would certainly invite you to do that. I think there's ample fact and law to support that conclusion, as we've argued in the brief. As a matter of fact, even the state agrees that with respect to who is covered by the right to keep and bear arms, as opposed to what kind of weapon is covered, Article 2, Section 13 sweeps more broadly than the Second Amendment. So I don't think that's really a contention here. The issue is how that reasonableness standard, however you interpret it, applies to HB 1224, with respect to which the evidence at trial was uncontested. The plaintiffs were the only one who put on evidence from an expert in guns, and the trial court adopted as a matter of fact the vast majority, well over 90% of magazines have detachable base plates. And the trial court adopted or held as a matter of fact that those detachable base plates can be swapped out with an extended capacity base plate that increases the ammunition. Those two factual holdings as a matter of law, which is how the facts apply to the law is reviewed de novo, should be dispositive, because we're saying that on the plain reading of the definition of large capacity magazine sweeps within it every magazine with a detachable base plate, which is in fact is practically every magazine.
Well, I think you're overlooking a few words, Mr. Arrington, in the definition. Do you have your brief handy?
Sure.
Turn, if you will, to page 10 of your opening brief. Top of the page, you say, "The constitutional challenge is grounded in the readily converted language of this definition," right? That's what you're saying there. And that, in answer to Judge Berger's question, you're saying this is really what you're arguing about, not so much the legal standard of Robertson shouldn't be applied, but you're arguing that this definition is overbroad. That's what you're arguing to us today, aren't you?
I'm arguing, I think the state has actually, in fact, conceded this, that if magazines with detachable base plates are described by the definition in House Bill 1224, the state concedes that that's constitutionally problematic. And they're saying that it doesn't, but we're saying that it does.
Okay, so let's take a look at the definition then. You've quoted on this page part, but not all of the definition there. A large capacity magazine means a detachable magazine. You left out the words "able to hold more than 15 rounds," I think is the actual language. Able to accept more than 15 rounds. That is designed to be readily converted. Now, as I understand it, you're saying this is overbroad because almost every magazine, detachable magazine, is designed to be readily converted.
And so if you want to look at the definition in its entirety, it's at the bottom of page 9. A fixed magazine that is designed to be readily converted to accept more than 15 rounds of ammunition.
And the words that you claim make this overbroad, because it sweeps all magazines into it, are the words "designed to be readily converted," correct?
That's correct.
Okay. So if those words were eliminated from that definition, you would not have a problem with the constitutionality of the statute?
No, that's not correct, Your Honor. We are saying that if you have a plain reading of this statute, and it is the magazines with removable base plates, which the trial court conceded are designed such that they are readily convertible to accept more than 15 rounds of magazine, sweeps in practically every magazine. That's just clearly unconstitutional. But we also say, further in the brief, that even if you limit it and say that only the magazines that are more than 15 rounds, that's still unconstitutional under Article 2, Section 13.
And why is it? Oh, go ahead.
Because the second half of actually probably the second third of our brief, talks about how that part of the analysis is such that firearm regulation is not reasonable because it is not designed to further a substantial government interest, and therefore it is unconstitutional. We're saying that that's part of the reasonableness analysis, that if you get into whether magazine bans generally are constitutional, as the Ninth Circuit just held in California, and I supplemented my authorities, they upheld an injunction of a magazine ban on the ground that it was not reasonably interested.
Second Amendment.
Second Amendment, and of course we're saying that the Article 2, Section 13 goes far beyond the Second Amendment. Second Amendment's a floor here, and we cite several cases to the effect that the court has held that the Colorado Constitution protects constitutional rights to, in some respects, a greater extent than the federal counterparts. We believe this is one of those instances.
So what do you think the words "or that it is designed to be readily converted," what does that mean?
Okay. While we're on page 10 of my brief, I did a plain and ordinary meaning of those words. Design means to plan, to fashion, to form, to structure.
Let me stop you there.
Go ahead.
Design is a verb, isn't it, as you defined it here?
Design is, I think that's
The
a
word
verb, yes.
used in the statute is not design as a verb. The word used in the statute is designed as an adjective, isn't it? Look at the statutory language.
Well, I think that the adjective incorporates the verb structure. I mean, it means essentially the same thing. I mean, whether and I think everybody understands. The trial court, in fact, held that the way these are designed, it is a fact that they're readily convertible.
But he also found they weren't intended.
See, then that's exactly the cusp of the disagreement.
And if designed as an adjective can also be defined as intended under the dictionary definition, that would support the trial judge's conclusion, would it not?
If of course, that runs headlong into the presumption against specific intent. We have here a situation where practically every magazine that has been designed has been in effect, has the effect of allowing it to be converted and to hold more rounds. Now, we're saying that under a plain and ordinary reading, your first and foremost rule of statutory construction, that should end the inquiry. But even if you get into the further statutory construction aids, statutory history, intent, etc., it goes further. So let's say that it's ambiguous, for the sake of argument, and I think that's what you're suggesting. It may be ambiguous. Let's go to the legislative history, your first tool in your toolbox with ambiguous statutes. 960 pages. The state did not cite to one of those pages to support its contention that it requires specific intent. We cited several pages of that. First, the prime sponsor said, what am I getting at? I'm getting at, if you take a magazine and you snap on something at the end like a Lego, that's what I'm getting at. What was proved at trial? That's how you do it. You take a magazine and you snap on something like a Lego. Senator Lumburn stood up and he told the Senate, this is what you're doing. This is what the effect of this is going to be. You're about to outlaw every magazine out there. No one disagreed with him, much less attempted to refute him.
But where does the doctrine, the rule of construction, that if there's two possible constructions of a statute, we choose the one that renders it constitutional? Where does that come into this mix?
That is the constitutional avoidance doctrine, and the constitutional avoidance doctrine cannot be used to resurrect a statute that is hopelessly unconstitutional. And as we say in this one,
But that begs the question, doesn't it?
well, if you say that we're going to require specific intent here, you've just effectively read that part of the statute clean out of the statutory definition. And I would point to something that the court mentioned in the earlier. How are you going to prove what that designer had in his mind? Are you going to call that? Is the designer even alive? Does he live in the United States? Is he subject to the subpoena power of the court? What was he thinking years and years ago?
I don't mean to interrupt, but you have 2.5 minutes left, and you said that you wanted to save some time for rebuttal.
Thank you. I'll reserve the rest of my time. Thank you.
May it please the court. My name is Matthew Grove. I am here on behalf of the governor, who is the defendant below. I'd like to focus my argument on three main issues today, although if there's anything else that the court would like me to address, I'm of course happy to do that. But these are the issues that I perceive as being the most important to the resolution of the case. First, how the reasonable exercise of police power test from Robertson should be applied in general and to the specific facts of this case. Second, plaintiff's argument that Section 1812-301 operates as a de facto ban on all detachable magazines. And third, the record support for the trial court's factual findings about the relationship between the General Assembly's stated goals in passing the legislation and the means that it chose for achieving those goals.
Mr. Grove, before you get there, does the state concede that if this statute has within its reach all cartridges that have removable base plates, that the statute's unconstitutional?
Yes, I would concede that. I would concede that if in fact this has operated a de facto ban on all detachable magazines that have a removable base plate, that yeah, it's unconstitutional.
And let me ask you before you start, does the state concede that gun ownership is a fundamental right under the Colorado Constitution?
We don't concede that, and we actually think that, as I argued at length and was discussed in the RMGO 1 opinion and in Robertson, that this court doesn't need to address it either. And in fact, Robertson suggests that it would be error for this court to even consider it. And so the fundamentalness of right to firearm ownership doesn't affect the analytical framework that this court should apply. In fact, Robertson says it's reasonable exercise, and that's the end of it, and you don't need to decide whether it's fundamental. It doesn't make a difference to the analysis under Article 2, Section 13, whether it is fundamental or not.
But doesn't the U.S. Supreme Court's Second Amendment jurisprudence provide a floor here? In other words, Colorado can do whatever it wants about guns, but it cannot violate the Second Amendment right that the U.S. Supreme Court has said existed. So doesn't that mean that maybe we do have to look at how the U.S. Supreme Court has said this right has to be evaluated?
I think the Colorado Supreme Court may well. It would not surprise me at all if it adjusts the approach that it took in Robertson in the wake of Heller and McDonald. But until it says otherwise, this court is bound by Robertson. Now, I agree, if Robertson had been a Second Amendment case, if it had had a Second Amendment component to it, that this court could then turn around and say, well, things have changed on the federal level, and we don't need to follow the Colorado Supreme Court's analysis of the Second Amendment. But the Colorado Supreme Court is the final word until it says otherwise with respect to Article 2, Section 13. That's particularly true given, the long-standing differences between what Article 2, Section 13 covers and the Second Amendment covers. The fact is, and the short version of this is that I don't think that this court can revisit Article 2, Section 13 unless and until the Colorado Supreme Court says otherwise. And so, reasonable exercise test, our position is that it controls. In addition to that, I think that, and Judge Berger, you asked about this earlier, I think that RMGO 1 actually is the law of the case here. I don't think that this court has the latitude to deviate from the analysis that it took. Yes, one division of the Court of Appeals is not bound by another, but when you're talking about the same case, I believe that the law of the case doctrine applies.
If we are firmly believe the prior division was wrong, you think we are duty-bound to follow it anyway?
I do, as a matter of the law of the case, not as a matter of the fact that you generally can go in a different direction than another division does, just because this is the same case. If it were two different cases, that would be another matter entirely. Regardless, the bottom line is that I think that the reasonable exercise test is something that will likely come up in the Supreme Court if this case gets there, and I'm sure Mr. Arrington will raise it then and we'll address it there. But for now...
Let me take you back to what you said before. You said if this statute banned, I'm not sure I have this right, banned large capacity magazines with detachable bases, that statute would be unconstitutionally broad?
No. I'm sorry. If it banned all magazines with a removable base plate. So the issue here is that you have magazines that hold less than 15 rounds when they come out of the box. But you can take the base plate off.
The 15-round limit.
Correct.
It saves the constitutionality, this you're saying.
Well, the argument that Mr. Arrington is raising is slightly different.
Okay.
He's saying that whether intentionally or not, that any magazine with a removable base plate is designed to be readily converted to hold more than 15 rounds because you can take the base plate off and put an extender onto it.
And the court found to the contrary.
The court found that
the design is there to help clean them.
yeah, the mere fact that a removable base plate is attached or that it is equipped onto the magazine does not mean that it is designed to be readily converted.
Okay. So my question to Mr. Arrington, although I'm not sure I quite got it out or got an answer, if the phrase detachable magazine that is designed to be readily converted was not in the statute, would the statute still achieve the same purpose that the legislature intended it to achieve, or would that gut the statute?
So if I understand you correctly, Judge Richmond, you're suggesting that if the statute just said you can't have a magazine that holds more than 15 rounds, period.
Right.
That would be one way of doing it. And I don't think that would pose any constitutional problems. It would be simpler. I think what the legislature here was doing was trying to provide a measure of flexibility and actually narrow the reach of the statute.
So if we decide that the words designed to be readily converted are ambiguous and, as they suggest, violate different rules of construction, could we just strike those words out of the statute? Is there a severability possibility here?
Well, I- we're several steps away from that. I mean, you would have to decide that, one, it's ambiguous, two, it cannot be interpreted in a manner that is consistent with constitutional norms, and then three, you apply a saving construction. And so, yeah, if we get there, and there may be another step I'm missing in that, but if we get there, I would not see any problem with striking out that language in order to preserve the constitutionality. I don't think you need to do that.
So
Mr.
we could
Grove?
rewrite the statute for the legislature if they got it wrong?
I'm not sure about, I wouldn't say that this is rewriting, and I'm not as familiar with this court's jurisprudence on the question of the difference between striking out and rewriting. But the Tenth Circuit certainly has, in a number of cases, been willing to line out particular parts of a statute and drawn a distinction between that and actually affirmatively rewriting it. Let me just say, I don't think you need to do any of that. But if we got that far down the rabbit hole, then I think that would be an acceptable approach in order to preserve the constitutionality.
Are you relying to any extent on the technical advisory letter, or whatever it's called, that the Attorney General issued? And if so, what exactly is the legal status of that document?
So there are really three things. There's the governor's signing statement, which urged a narrow construction that is consistent with constitutional requirements, and two technical guidance letters, which were drafted in accordance with the governor's instructions. Those aren't binding on this court. The RMGO1 court made that clear, and I agree with that principle. But what they do demonstrate, particularly the technical guidance letters, is that there is a reasonable common sense interpretation of 1812-301 and the designed to be readily converted language that comports with whatever the constitutional requirements are. That is, they tie in and are relevant to the question of constitutional avoidance. That is, that they present a completely reasonable interpretation that is completely constitutional. And so this court isn't bound by them, but to the extent that it can look at them and agree that it's a reasonable interpretation, we'd urge the court to adopt that rather than straining to adopt an interpretation that expands the reach of this to basically ban any sort of magazine that is equipped in the way that we're talking about. I'd like to talk a little bit about how the reasonable exercise test works, because I think that is Robertson is not all that clear on this, and it was decided 25 years ago, and we have a couple of cases that have discussed it to some extent subsequent to that, but we don't have anything from the Colorado Supreme Court, and we don't have a great deal of detailed discussion from this court. There are four cases that I'm familiar with, and I think I've caught them all, that have applied the reasonable exercise test post-Robertson, and those are RMGO1, the one in this case, Students for Concealed Carry, the People v. Sandoval case, which is a criminal case, and so takes a bit of a different approach, and Trinan versus City and County of Denver. Now, Trinan, among those cases, is the outlier. It equated reasonable exercise to rational basis. We're not taking the position here that is consistent with the framework that Robertson suggested. Instead, we think that the better approach and the most thorough analysis of what reasonable exercise means shows up in Students for Concealed Carry. And in that case, from that case, we can glean that there are really three differences between reasonable exercise and rational basis. One, reasonable exercise, and this is probably the most important one, reasonable exercise presents a mixed question of fact and law versus rational basis, which poses purely a legal question. And so that's why we're here after a trial, is because the court said, well, this is a mixed question of fact and law, we need to send it back. So we went back, got those factual findings, and now we're back here.
I think you should address those in the few minutes you have left, because you said you're going to talk about the facts that support the legislative determination.
Sure, I can do that. When you're applying the reasonable exercise test, what you need to show, what needs to be determined by the court, I don't want to talk about the burden here too much, is that an act is within the state's police power and is therefore consistent with Article 2, Section 13, if it is reasonably related to a legitimate governmental interest such as the public health, safety, or welfare. And so what we have to determine here is whether there is a legitimate governmental interest at stake here. If you look through the legislative history, if you look to what we proved, The legitimate governmental interest here is prevention of mass shootings or reduction of harms associated with mass shootings. That is the number of people killed, the number of people injured in any particular incident. There's also some discussion in the legislative history, and we presented some evidence on this at trial, specifically related to the dangers posed to law enforcement officers by criminals who are equipped with large capacity magazines. So there we have our legitimate governmental interest. In fact, I would assert that that's a compelling governmental interest, and many other federal courts who have analyzed this under intermediate scrutiny in the Second Amendment have agreed with that. So the second question then is there a reasonable relationship between that governmental interest and the means that the legislature employed to address the evils that they perceived were associated with this? And the evidence at trial showed that, in fact, there was. The factual findings, and many of these are uncontested, and all of them have substantial record support, whether or not they were contested, demonstrate that there is a clear link between the use of large capacity magazines in gun massacres and mass shootings, however you define those, and the adverse impacts that those cause. That is, the specific factual finding is that if a large capacity magazine, as defined by the legislature in this, that is one that holds more than 15 rounds, is used in a mass shooting, 40% more people are killed than a mass shooting in which the mass shooter is not equipped similarly, and 2 to 3 more times people are injured in those. Now, the trial and the record in this case predated a number of tragic incidents that probably would have changed those numbers significantly and not in the plaintiff's favor. But be that as it may, the record here clearly shows that there is a direct link between large capacity magazine use in mass shootings and the injuries and harm that they inflict. Now, on the other side of the ledger is this constitutional floor that the Supreme Court has set in Nakamura, in People v. Blue, and in Robertson, and that is the Supreme Court has said the legislature can't adopt laws that abrogate the rights that are protected in Article 2, Section 13, which I read as you can't prevent people from defending themselves. And so on the other side of the ledger there's the question of whether by limiting magazine capacity the legislature did this. And again, we have clear findings and clear record support to demonstrate that limiting magazine capacity in the way that the legislature did has no such effect. And in essence, large numbers of, given the differing objectives of someone who is trying to defend him or herself with a firearm versus a mass shooting, you don't need more than 15 rounds to defend yourself. That's what the evidence showed. Yes, there are probably 1 in a billion circumstances where that might happen. There's no evidence in front of the court to demonstrate that.
Does the Colorado Amendment protect sport shooters, target shooters, hunters as well? Does the limitation on large capacity magazine affect their interest if those interests are protected?
To the extent that it does, those rights aren't in the same sort of core. Whether you can go out and shoot targets 15 times or 30 times is not, it might be important to you, but it is certainly not as important as protecting your home. And there's also no showing that being able to shoot a target 15 times rather than 30 is going to adversely impact your ability to use your firearm consistent with its intended use.
And Mr. Grove, your time is up.
We would ask that you affirm. Thank you.
Mr. Arrington, you have 2 minutes and 23 seconds for rebuttal.
With respect to the self-defense question, the state's own witness was led through a series of questions from his book about how a large capacity magazine increases the effectiveness of a firearm in the hands of a criminal. And I asked him, I said, 1 by 1. Same thing with someone defending his house, right? 1 by 1 by 1 by 1. He said, yes, 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 yes. And so the state's own witness said that a large capacity magazine increases the effectiveness of a weapon for self-defense purposes, which is at the very core of the self-defense right protected by Article 2, Section 13.
But that's not what the trial court found.
Yeah.
The trial
And-
court wasn't required to accept any of this evidence.
I'm sorry?
The trial court wasn't bound to accept any particular evidence, and the trial court found exactly the opposite of what you just said. And if there's record support, which I think there is, we're bound by that, aren't we?
Unless it's clearly erroneous, and I would suggest that when the state's own witness says that it decreases the effectiveness of a weapon for defense against a criminal, that's clearly erroneous for the court to have ignored the state's witness in that respect. With respect to the severance issue, certainly that's within this bundle, the bundle of remedies this court has. I think that in order to sever, though, nobody's suggested this before, and we were into this 5 years now. You would have to find that that definitional part is not integral to the statute. The Senate sponsor said it was integral to the statute, in my view. She didn't use those words, but she said the purpose of this is to prevent someone from having a technically compliant magazine that can be converted within a matter of seconds into a non-compliant magazine, which is what the plaintiff's expert did. He had 4 magazines there. He said were representative of the vast majority. 16 seconds in one. 37 seconds in the other. That was the most it took. So the fact of the matter is, if you interpret it such that it doesn't apply to those magazines, you've read it out of the statute. Why would someone design a magazine that is specifically, the specific purpose of which is to exceed the 15-round magazine limitation, if you already have millions of them out there that do that very thing? It makes no sense to interpret the statute that way. And finally, with respect to Article 2,
Mr. Arrington, your time is up.
Oh, I'm sorry. Thank you.
Thank you both for your very interesting arguments. The case will stand submitted, and an opinion will issue in due course. The court is now going to take a short recess, and then we'll get ready for the 2:30 docket right after that, and the bailiff shall so announce. afternoon, please be seated. And again, welcome to Division 5 of the Colorado Court of Appeals. I know some of you weren't here the first time I went through this, so I'll go through it again. My name is Gilbert Roman. I'll be the presiding judge today. To my right is Judge David Richmond. To my left is Judge Mike Berger. And we have one case left on the docket, and that is Lang versus DeFada. And this is procedurally a case that's set up differently than what we're used to, so I want to make sure that everybody's on the same page in terms of procedurally how we're going to proceed. There are 3 parties, and you've each been given 12 minutes to present. And my understanding, and correct me if I'm wrong, is that the applicants are going to go first, the board is going to go second, right? And the objectors are going to go third, right? Okay, then, do you have any questions for me then before we start? Because again, it's a little different than usual. All right, then what I would say is to all of you and to anybody out there is if you have a phone or a device that would make noise, please turn it off at this time. And I would remind you all that this is being live streamed and that it will also go into the court archives. And with that, we are ready to proceed. Please proceed.
May it please the court, my name is Brett Lilly. I'm here representing Big Bear Liquor West, Inc. They're with me behind the council table. It's hard to believe this case has been going on for 3 years, and I think it's important to remember why we are here in the first place. And that's because the trial court, sua sponte, on its own, out of the blue, without notice and without opportunity to be heard, wrongfully took away Big Bear's liquor license. And it's
When you
important.
say wrongfully took away, isn't it true that they never actually got a liquor license?
Well, if you look at the record, first, I guess it depends on what you mean by got a liquor license. They were granted a
Well,
license.
you get this thing that you put up on the wall that says liquor license. They never got that, did they?
That would be what I would consider opening the store. They were granted a license by the board, and they were granted a license by the state. The state is at court file page 1991, and the record from the board is court file page 1715.
What was the reference on the state?
Page 1991. That was Exhibit B that was attached to the motion to reconsider. The whole thing Exhibit A. The whole thing was the case summary and report, but if you look particularly on page 1991, it says specifically the liquor license was approved on September 2nd, 2015, and it even has a license number, for what it's worth, 4704985. But to jump to what your question is really getting is, well, let me back up and I'll get to it. First of all, what we're asking this court to hold is that our name is not a direct or indirect interest prohibited by 1247-4074A. That statute's going to be recodified October 1st at 443409, but the language is exactly the same. The second thing that we're going to ask this court for is to say that we qualify for additional licenses because our license was taken away, and that's under 1247-4074B.
But you gave up the premises, didn't you?
Yes, and that was because, as in many liquor licenses appeal, they couldn't afford to pay the lease. And so the quid pro quo was to surrender the premises in exchange for not being held in default on the lease.
So it's impossible under state law for your client to get a liquor license at that location now?
At that location, yes. And furthermore, it's impossible for them to get a license under their current name at any location because of the trial court's ruling that their name was a prohibited interest. That's the 4A claim. The 4B claim, which is what I think you're getting at, Your Honor, is exactly this, that I think to say that we didn't have a license because we didn't have it on the wall and we weren't open is overly technical in this case. What happened was we were granted a license by the board, we were granted a license by the state, and then the trial court, out of the blue, which even the plaintiff has never defended their theory in the 3 years since that ruling came down, that's how out of the blue it was. So because it was such a crazy theory that we never had an opportunity to argue or defend, that's why the license was wrongfully taken away. And so what we're saying is that even though we can't open in that particular location, we still have two remedies available to us under the liquor code. Under 4A, we need to clear the cloud on our name so that we can use the name Big Bear Liquor West and apply for any license. And then second of all, we want a ruling from this court that says we were actually granted and approved a license before January 1st, 2016, and that puts us into the window under Section 4B that says we qualify for not just one license, but up to 4 more additional licenses.
When was the state license issued?
It was issued on September 2nd, 2015. And so sure, you could say, look, you didn't open the store, therefore you didn't have a license. And I think in any other liquor license case, that's the line that has to be drawn. In other words, at the point you're open is the point you have a license. But because of the due process violation here, I think this court has to not look at the technical aspects of the law, but you have to look at the spirit of the law. The spirit of the law is that these people put a lot of time, money, and effort into opening a liquor store. That rug was yanked out from under them by the trial court. And forgive me for saying so, but for this court to rule technically that because you didn't have a license, we're going to say that you're moot or whatever, would be trying to brush this case under the rug by this court.
What exactly is the due process violation you're claiming?
The due process violation, Your Honor, is that on a 106 appeal, the trial court is supposed to look at the record. And the trial court went beyond the record and came up with a theory that was never argued by the plaintiff, never argued by the board, and most importantly, we being Big Bear, never had notice of that theory, and we never had an opportunity to respond. And I think under any test of due process, both procedurally and substantively, to take a valuable liquor license away, a valuable invested right away under those circumstances is wrong. And this court has a responsibility and a duty to correct what the trial court did. And, you know, we're not talking about this court reversing the liquor board or the governor or the legislator. We're talking about this court policing the judicial branch. This is a case where a judge made a mistake, and this court has a duty and a responsibility to correct that mistake.
So what precisely do you want us to say?
I want you to say, first of all, that our name is not a direct or indirect interest prohibited under Section 1247, 407, 4A. That's the direct ruling of the trial court. And then secondly, we want this court to say that we were granted a license on or before January 1st, 2016, and therefore qualify for additional licenses under 1247, 407, 4B. That's exactly the remedy that we want.
Did you seek a stay of the district court's order?
We did.
And I gather it was denied.
It was denied.
You want us to say that the name Big Bear is not a direct interest?
It's not an unlawful interest under the language of 1247, 407.
In other words, reverse what the district court concluded.
Yes.
But what impact? What impact would that have? What's the difference? Until they apply for another liquor license, until some other court says, oh, you can't use that name, what?
I would respectfully disagree, and more to the point, as a lawyer, I'm not going to roll those dice. And here's what I mean, Your Honors, is that right now there's a district court order that isn't talking about a premise, it's not talking about needs and desires, it's talking about our business name. In other words, this ruling is particular to us, and so I think that order follows us. If we're to apply for another liquor license, there's nothing to stop Mr. Sternal from standing up and saying, look, there's a court order that you did not challenge and therefore is barred by what I still call res judicata, but what is now called claim or issue preclusion. In other words, if we don't challenge that trial court order, it's still a valid order, and it prohibits us from applying under the direct language of 4074A from applying for any additional licenses. So I would respectfully submit that we're barred from applying for any license.
There was no, you say your due process was deprived because there was no litigation of that issue before the district court. Aren't there facts relevant to that legal determination? that you want
I'm
us
sorry,
to
Your
make?
Honor, I don't quite follow your question.
Well, there was no factual presentation before the district court on the direct interest aspect of that name, was there?
Not on the name argument,
Right.
and that's because it wasn't argued in front of the board either.
Okay, that too. So doesn't it require some fact determination or fact finding to decide what I think is a legal question that we can't do? We can't do the fact finding.
Well, you're probably right in the normal course, and what the trial court should have done is under Rule 106 is send it back down to the board and said, you should have made findings on this and you didn't. We filed a motion to reconsider, which the trial court denied, suggesting that remedy, and she refused. And so therefore, we're in this kind of quandary where nobody's ever had a chance to argue it or litigate it, and the only person who ever thought of it was the trial court judge. And so I would respectfully submit under these circumstances, Your Honor, because nobody has defended the name before or since, and more importantly, the board and the state, if you look at if you look at the record, which is court file 1900 to 1999, page 1990 to page 1999, that is the report of the state. And I encourage this court to read through it very carefully. You'll note that Mr. Sternal voraciously made his arguments. The state very thoroughly investigated this, and they found no prohibited interest. Furthermore, directly to your point, Your Honor, if you look at Exhibit B that was attached to that, and that's court file page 2000 to page 2038, that is the public record of all the liquor store licenses that were issued at the time this case came up. If you look at it, there are at least 54 liquor licenses with the same or similar name in 12 jurisdictions, and there are many similar names in other jurisdictions. The point is this, is that neither the state nor the board has ever considered a trade name a prohibited interest under 407, what was 4 and now is 4A. And I think because we're here on a Rule 106 review, that is binding and dispositive.
Mr. Lilly, if we vacate the district court's order, does that solve your problem?
I think that you need to reverse the district court's order. In other words, the rationale and the reasoning of the trial court isn't something that should just go away. It needs to be specifically reversed.
No, but your problem, as I understand it, I guess it's a claim collateral consequence, is that your client's going to be prejudiced by this finding that was made by the district court on the 106. If we vacate the 106 order, there's nothing to apply to prejudice your client.
I guess that would be an acceptable fallback position, Your Honor, but my position would be that this rationale is so offensive. I mean, it puts, if this rationale isn't reversed, how many other liquor store licenses are in jeopardy? A vast number of them. In other words, this was a monkey wrench thrown into the machine.
You don't get to argue the rights of other people. You get to argue your client's rights. Anyone else who has similar situation, they can go before the 106 court. The 106 court might or might not do the same thing that this judge did, and then they could take an appeal. So you don't get to argue other people's rights.
Fair enough, Your Honor. I guess I'm just trying to point out that the rationale and the reasoning of the trial court is important and I think needs to be addressed by this court. And that's why we believe that it should be reversed.
And Mr. Lilly, your time's up.
Thank you very much, Your Honor.
Good afternoon. Gavin Wolney, registration number 46342, on behalf of the Pueblo County Liquor and Marijuana Licensing Board. Court, today, the issue I'd like to present and discuss further is the question of mootness. As you know, this case was remanded for additional factual findings on the question of mootness, and it's the board's position that even though we've argued that an exception applies, it's the board's position that this case is moot. And I'd like to develop that briefly. So a case is generally moot where changed circumstances meet.
Before you get there, I just got to understand, you're saying that your claim, for whatever reason, is not moot?
I apologize. I believe our claim is moot, but in our brief, we suggested that an exception to the doctrine of mootness, because it's capable of repetition and evading review, can be applied in this circumstance. But I think it's important, based on the remand, to acknowledge our position that this case is moot. First and foremost, regardless of whether the court accepts our theory for an exception to apply in this case.
I don't understand that. Are you asking us to grant you relief or not?
Yes, Your Honor, we are.
What relief are you asking us to enter?
We would ask for a reversal on the grounds that the burdens and presumptions that the standard of review that the district court applied were incorrect, and they apply to every 106 action that could arise. And for that reason, from the board's interests, this involves more than just the case at hand, and that was the reason for our appeal. Our position is that the government body's decision under 106 is presumed valid unless a plaintiff bears his burden in determining otherwise. Our position is that the court itself the court itself said that the relief was granted in this case for reasons other than those proffered by the plaintiff. And the trade name similarity theory was the sole basis for reversing the board's decision. And so our position on appeal is that that is an incorrect application of the burdens and presumptions that instruct a court on how it should review a case under 106.
So
Well,
are
why
you
can't-
happy if we vacate the 106 order?
Yes, I would be happy with that. I would be happy with that. My biggest point is to get instruction on how this burden and presumption applies to 106 cases. That was the reason for our appeal, and that's the reason why I'm asking for an exception to mootness. But barring that, I agree that vacating the trial court's order is fine because I agree that this case is moot, and typically that would be the remedy, I believe, in a case where it's moot.
So why wouldn't the next case, with its own specific challenges, simply address your concern?
That's a good question. First, if a review of the appellate level cases on 106 shows that the typical case is a denial where the applicant appeals. We have a rare case here where it was an approval where objectors sued and got the trial court to reverse. So this would help illuminate how the standard of review is applied in that particular situation. And the other thing is that business realities that the applicant just mentioned about not being able to pay your landlord and things like that would often come into play sooner than you could reach the appellate courts in cases like this. And so that's the reason why I think it's a question that may never or may rarely present itself before this court.
If we find this case is moot, our usual remedy is dismiss the appeal, not vacate a district court order.
I apologize, Your Honor. That remedy would also be fine with us. I guess I would say our alternative argument is that if you do not find that this question on the standard of review is not proper to take, our alternative argument is that this appeal should be dismissed as moot. We think that the subsequent application and the district court findings, both from a practical and legal matter, make this case moot. From a practical matter, we have the applicant admitting that they have no intention to operate at the premises that were approved.
But to make you very happy, what do you really want us to do?
I would like some instruction on how the standard of review is applied. That's the biggest thing that the county is looking for.
So you want us to just give an advisory opinion as to how
No.
judges ought to rule in a 106?
No, Your Honor. I would not call it an advisory opinion. I believe because of how rare these cases are, I believe that an exception to the mootness doctrine can be found here, and I believe an opinion reversing the district court's order would be proper to give light to what the standard of review is. But I also don't want to shy away from the fact that I believe in good faith that this case is moot. And I would like to briefly address the counter-arguments to mootness raised by the appellant. The first is, I don't believe that having a license to hang on your wall is a technicality. It's a statutory requirement, and until the building is ready for occupancy, no local license can be issued. And to qualify for the multiple license right, you would need to have been licensed, fully licensed, we would contend, as of January 1st, 2016.
Is it the licensure that triggers this the right over time to get 4 licenses, or the operation of a liquor store? Which is it?
It's the licensure. The statute reads licensed on or before January 1st of 2016. Our position is that surely there was a state license on January 1st of 2016, and there was a decision by the local licensing authority on that date. But no local license can issue under the liquor code unless a certificate of occupancy is shown to the board and the readiness of the building is proved. And that statutory site is 1247-312 subsection 4. So it's codified in statute, and it's a bar on local licensing authorities from issuing a license until operations are ready. So our position would be licensed on or before January 1st, 2016 means fully licensed, not just approved.
So you're saying within the meaning of the statute, they were not licensed as of January 1, 2016?
That is the board's position, yes. In our position on the question about the trade name, we have a different reading of the judge's order on that as well. If you look at the district court's order on the question of the trade name, it was a fact-specific analysis. And our position is the use of the trade name is certainly barred at the Haley Lane location, the location for which the applicant applied. I do not read the district court's order so broadly as to prohibit it in all circumstances. The district court judge looked at, for example, the identity of the applicant, the goodwill generated by the existing liquor store with a similar name in the area, local familiarity with the existing store, and even the geographic proximity. So all those factors that the district court analyzed in the record lead me to believe that the problem with the trade name is specific to the location in this case and not a general bar on new applications. So I would respectfully disagree with the theories that that would theoretically keep this case alive. We think that those two theories are incorrect and that the case is fully moot. And judges, I would ask to reserve the remaining time for rebuttal.
Very well. You have 4 minutes and 19 seconds.
Thank you.
Lee Sternal, Pueblo. I'm going to make an effort to assist you at this time, but frankly, I'm not exactly sure where I should start. But my first comment is that having been subject to the rules of procedure that were imposed on me by the county commissioners gave me a new appreciation for the wisdom of what the other court in this building did when it abolished all local rules of civil procedure. And
Mr. Sternal, let me ask you the same question I asked the other lawyers. What will make you happy in this case?
For you to give instruction to the Pueblo County Commissioners. They're asking for instruction. They need to be instructed, number one, that when someone wants to put on a hearing in front of them, they are subject to the Administrative Procedure Code's right to use subpoenas. They have rejected that.
How do we have the authority to assert supervisory jurisdiction over this board? Where do we get that authority?
You just look at what the 2007 amendment said to the APC, which said that in any hearing where a license is issued, these provisions shall be applicable, and one of those specific provisions is the right to a subpoena.
Right, but what authority, what jurisdictional authority gives us the right, other than in an appeal of a particular adverse determination or order, gives us the right to tell an administrative board how to do their job?
Well, you're not telling them how to do the job when you're telling them that there's a basic right to the subpoena. If you're going to present evidence, the statute says we get to present evidence. What does the presentation of evidence mean in the common sense of how we all understand it, it includes the right to use subpoenas. And when you're talking about needing to have witnesses who are really important but have an interest which is adverse to another party, they aren't going to just voluntarily show up. So from my point of view, they need to be instructed on due process. And one of those issues is that they should admit that they are subject to the requirements of the Administrative Procedure Code. But a more important instruction is that they need to recognize that they must follow the language of the statute. The statute says you don't just get one of these licenses because you'd like to have it. You have to show two things. You have to show that the requirements of the neighborhood are not being met, and you have to show that the adult inhabitants of the designated neighborhood desire it. Those are the two elements that have to be established.
All right, so the liquor authority ruled against your clients on those 2 points?
The liquor authority did nothing except affirm what had been done by the local board. They didn't even give me a chance to talk to them.
But-
All they do is,
All
yes,
right,
the
all
liquor authority at the state, or are you talking about the local
The
authority?
local authority.
Oh, the local authority ruled against me on that, incredibly.
Okay, so then you would have appealed that, except for the fact that the license went away. So what is there for us to decide? It doesn't make any difference now what the
No,
neighbors
there's a
thought.
really important issue here for you to decide, which is the fact that what you're talking about with this applicant here is a corporation that wants to have a bunch of other stores, and they want to go through the same process of petitioning for these stores the same way they did for this one, which was to use a petition which is inadequate, which has been determined to not be of any use, and yet it's been accepted by this local liquor
All
licensing
right, so if they
authority.
do it again, and they use the petition again, and for some reason you have clients who want to challenge it again,
Well, Judge, it costs a fortune to challenge these things. These poor people that are husband and wife liquor store owners can't afford to come out and spend $50,000 or so to get a lawyer to get involved fighting some big law firm here in Denver. And so the point is, you can do an awful lot to help these people right now by just simply saying, look, you aren't allowed to have a liquor license unless you meet these burdens of proof. They were not met in this case, and therefore you never should have been given that license by the local authority. But more importantly, you've got a chance here to go back and do what sometimes this court does, which is look at the record in front of a district court and say, look, even though we don't necessarily agree with what this district court did, we can see that they did it for a reason which falls within the proper scope of what they said. And of course, what we're talking about here is this, at that time, prohibition against direct or indirect interest.
Mr. Sternal, do you agree that the case is moot?
No, it's not moot from the point of view of the fact that if this court were to say that this license was improperly approved, there'd then be basis to go back and say, wait a minute, it was improperly approved because the standard wasn't met, and so the grounds exist that it can be used to challenge the existing license.
So are you asking for an exception to the mootness doctrine, or are you,
No,
are you
I'm
saying
just
it's
saying,
just
look,
not
mootness,
moot?
mootness only can be imposed if there's no chance it's going to, not no chance, but if there's little chance it's going to be repeated. You don't just declare something moot unless there's certain elements that are met, and one of the big ones is that there's not a likelihood it's going to be repeated. What we have here with Pueblo County is an extreme likelihood they're going to repeat it. They already have when they went ahead and granted this license the second time it came up, which incidentally is a separate issue that I would think would be of interest to you when this board goes ahead and sits as the judge at the same time they're already the appellant up here. I
Did you
think
challenge that?
I sure did. I did. At the time, I gave them an affidavit of bias. I gave it to them before this second hearing was taking place, and they never even gave it to the board members. In fact, at the time that hearing started, I had to call it to their attention, and the board members then for the first time got a chance to look at it. And I was asking them in that affidavit of bias, which was done under the Administrative Procedure Code, that they vacate that hearing at that time and hold off until we see what you folks did with the issues that had been raised to you. And of course, they didn't want to do that, and they thought it was okay for them to go ahead and have another hearing on the same application, essentially, even though they were already up here fighting the fact that the first time they gave the license, it was overturned.
Did you file a 106 challenging it?
Did I file a second action? No. I don't have clients who can afford to file a second action. They shouldn't be in the position of having to do that. It costs a lot of money to file these things. You've got to get a transcript. All of this is something that they would have had to do after this family, the Lucas family, had already got their new building up. Now keep in mind, this was a race from the time that license was approved by the board until the time it was overturned by the district court. There was a race going on to see if they were going to get that license hung on the wall before the judge had a chance to decide whether or not it should have been granted. So anyway, after the building was up.
So we asked the other council what they want us to do, and I don't think anybody's asked you yet. What
I
do you
want you
us
to
do?
affirm the district court, affirm the district court's reversal of the license.
Because of the direct interest situation, right?
That, and not only that.
And then reverse on the grounds that the subpoena should have been issued?
Well, that's not as important an issue. The
That's
two,
what we started with.
well, sure, because procedure is something that I think was raised by them.
Right.
But,
So you
and
just want us to affirm the district court's opinion?
well, what I want is a decision which affirms it, but for the reasons I had argued to it, which were there were two violations here. One was the illegal indirect or direct interest, and the other was that there was a failure of the burden of proof issues.
But the court did find in your favor on the failure of burden of proof.
No, they didn't, but when it was a 1,200 to 0 score, you wonder why they didn't.
Then, in order to give you relief, we would have to reverse the district court's decision. So you're
No.
saying you want us to affirm it?
No, you affirm it, and you can say you can affirm it for a couple of reasons, because there's evidence there to support what the court did, first of all, in saying the statute was violated, and secondly, there's other evidence that would affirm it, so you can do it. And of course, you'd be doing a great favor to everybody down in Pueblo County if the thing comes up again in any form. So I guess I've got 3 minutes left, so I'll wait until I see if I need to use that.
Very good. You have
Thank
2
you.
minutes and 55 seconds left. Mr. Walney, you have 4 minutes and 18 seconds for rebuttal.
Thank you, Court. I'd just briefly like to address a single point that Mr. Sternal raised on the idea that a decision from this court would enable a challenge to the second business that applied to that applied at the same location. If that's the way I heard it, my position is that the exclusive remedy for a licensing decision is an independent 106A4 action. I think it's beyond the jurisdiction of this court to order any relief against the second business, which isn't a party to this case, and also was licensed as a result of a second proceeding and a second decision. So I don't think there's a way that relief from this court could serve as a basis for challenging that second license now that the time under 106A4 has elapsed in that case.
Who suggested that?
I may have misheard that, and if I did, I apologize. I thought I heard the plaintiff say that a decision from this court could serve as a basis for challenging the second license. If I heard that incorrectly, I apologize.
I thought it was the opposite. They were claiming they would be somehow stopped based upon the 106 order in this case that had not been successfully appealed. I thought that's what they were arguing.
Well, if that's the case, I apologize. It's stopped from operating at their current location?
Well, no, if they were to make another application that
Oh,
somehow.
I see. If that's the case,
Somehow
then,
the 106 order would prevent that application, I don't know.
if that's the case, then yeah, I think it would provide guidance. If I misheard that part, I apologize. That was the only point I wanted to make.
Thank you, counsel. Mr. Sternal, you have 2 minutes and 55 seconds.
I think Mr. Townie might have been reading my mind, because I was thinking, yes, there could be another action, but it would be based on Rule 60, which gives the right of an independent action to unwind or correct an incorrect judgment that was entered by somebody earlier. And in fact, when I was listening to counsel for Big Bear argue, it occurred to me that he was laying out a perfect situation for such a Rule 60 argument. What he's talking about is making an argument to a different judge concerning a different issue, which is getting relief from what he didn't like about what happened with the district court in Pueblo. We have Rule 60. It creates the right for independent actions to correct something that looks wrong because it was done improperly by another judge. So let's not forget about that potential. And in terms of what I'm talking about, my clients aren't in a position to go fighting this thing at another level, but somebody else might be interested in it if it gets declared that the petition format that was used to approve this was in violation of the requirements for proof to be able to have a retail liquor license. And
Anything else?
I-
Thank you, Mr. Strano. Unless you still have a minute 35 if you want.
well, I'm
I don't mean to rush you.
I was just hoping to see some kind of response from you over the idea that this board down there in Pueblo got to be an appellant at the same time they were the judge of the same fact situation. I think that some comment to that effect could be helpful. Thank you.
Thank you. Thank you, counsel, for your arguments and for your patience as we set this up a little differently than we normally do, as I said at the very beginning. The case will stand submitted and an opinion will issue in due course. That concludes the court's docket for today, and the bailiff shall so announce.